morning. Seeing that this is such an informal group, it's only befitting because our panel today is also on themes of informalism and informality. I'm Maryam Khan, and I'm a research fellow at IDEAS. I'm a legal scholar, and I study law, legal institutions, and legal actors through the lens of law and society, as does the entire panel here. I also look at social movements, how they interact with the law and the state, and finally, I study politics of constitution making and constitutional design. And today, I have the immense pleasure of moderating this panel on administering justice that has been put together by a group of early career socio-legal scholars on Pakistan, who bring to bear some very interesting and innovative interdisciplinary lenses on law in Pakistan, particularly its implementation, its enforcement, and its practices on the ground. Now, what brought us together was not just this panel per se, but some very interesting conversations during this entire year, and a realization of some very striking commonalities across our work in viewing how law works in action in Pakistan. From there, we developed a working group to explore the theme of legal informalism, which at its core is the idea that in our post-colonial context, we see the existence of parallel structures of law, the formal and the informal, and that what often determines outcomes in our legal and justice system is the informal rather than the formal, or that there is really this contingent interplay between the formal and the informal, so that the law on the books is seldom the law on the ground, and in fact that gap is really huge. From this conventional notion of legal informalism, the idea which focuses only on alternative orderings of the law, we expanded this to a broader notion of informality, which is an idea that we're borrowing from urban studies. So we're trying to bring together interdisciplinary fields of law, like law and society, with other fields outside of law, like urban studies, to really try and understand informalism or informality, whichever way you want to put it, not just in terms of informal structures of law, but also the entire gamut, if you will, of informal relations, practices, and norms that impact the formal law, right? And just to give you a flavor of the kinds of questions we're going to be looking at in the context of these themes, first of all, we're going to explore how do historical institutional inequalities and structural violence within law enforcement agencies perpetuate informal practices in everyday police work? How does this, in turn, condition the implementation of formal laws and procedures? Another work that is being done has to do with constitutional interpretation, right? How does that impact, or how rather is it impacted by informal institutions that structure authority, interactions, and relationships between different actors within the legal complex, in the larger context of our hybrid regime politics? And conversely also, how do changes in the constitutional framework alter the relational dynamics of the legal complex? And by legal complex, it's a term of art used in the literature to really look at law, not just in terms of the more visible or ubiquitous institutions like the judiciary, but to look at legal bars, the socioeconomic relations within them, police, what are some of the other actors, prosecutors, so on and so forth. And finally, another area we're looking at is labor law. So what do the silences and omissions in the interpretation of formal labor law and policy tell us about the conditions of labor extraction and remuneration, and the ways in which unwritten rules and customary practices might mitigate adverse working conditions to make labor extraction frictionless and cost efficient. So these are the kinds of themes that we're going to be looking at, and I will now just briefly introduce my panel members here. We have Dr. Zoha Waseem, who is an assistant professor in criminology at the Department of Sociology, University of Warwick. She is the coordinator of the International Network on Urban Violence Research Network. Her book, Insecure Guardians, Enforcement, Encounters, and Everyday Policing in Post-Colonial Karachi, has been recently, in fact, this very year, published by Hearst and Oxford University Press. And the book explores how security policies tailored towards the interests of insecure elites and regime protection influence the culture of everyday policing in post-colonial contexts. We also have here with us Dr. Yasser Kureshi, who is a department lecturer in South Asian Studies at the University of Oxford. Working at the intersection of political science and public law, he studies the military and the judiciary and their impact on constitutional configurations and democratic outcomes in authoritarian and post-authoritarian states. Yasser also has a book out this very year. It's called Seeking Supremacy, The Pursuit of Judicial Power in Pakistan, published by the Cambridge University Press. It examines the emergence of Pakistan's assertive judiciary, and I think assertive is a bit of an understatement, right? And our third and final speaker is Palvasha Shahab, who is visiting faculty at the Social Science Department at IBA. She's a Karachi-based social justice lawyer, researcher, and trainer. She's an LLM from Columbia Law School and happens actually to be an alumni of the BA LLB program here at LUMS. Her practice has been spread along the lines of socioeconomic rights, conditions of labor, gender, particularly sexual violence, and environmental justice, and she's previously served as the Joint Executive Director of the Pakistan Center for Constitutional and Human Rights, as well as the Legal Aid Foundation for Victims of Rape and Sexual Assault. And without further ado, I'm going to now invite Dr. Zoha Waseem to present her work. Thank you so much.
Thank you. Can you guys hear me? I'm not sure if this is working, but yeah. Okay, that's fine. So hi, everyone. Thank you for attending this panel. Thank you for Maryam for organizing this whole project and panel, really. So for this paper, I'm basically relying on some of the research I have been doing, conducting on policing and security provision in Pakistan over the past few years, and some work that is currently also under development. But essentially, most of the research is sort of drawing upon ethnographic work that I have been conducting in Karachi, primarily since 2015, but also some supplementary research that I've been conducting in other cities and during the COVID-19 pandemic. So first, I'm going to talk a little bit about how I'm approaching this idea of informality in my own research on police work and the provision of security labor, on insecurity, and the politics of policing. Then I'm going to follow up with some examples of where and how informality can be seen to be mobilized and how it's enabled and facilitated by various factors. So broadly, I'm suggesting that informality in police work is facilitated by a few factors. So first, by the insecurity and vulnerability that's faced by officers or officials themselves, often in the face of political violence and extreme uncertainty, especially during counterterrorism operations, for example. And of course, vulnerability that's created by virtue of their own position within their organizations, which necessitates often reliance upon informal institutions or the norms, rules, procedures that are created, communicated, and enforced outside of officially sanctioned channels. Second, it's facilitated by opportunities created for developing institutional and social networks, institutional and social relationships and networks of patronage. Third, how it's facilitated by problematic security and criminal justice policies designed by insecure regimes around issues such as immigration, for instance, that place certain demands on law enforcement officers. All of this is, of course, enabled by a lack of accountability structures and oversight mechanisms, which validate some of the concerns around limitations of institutional reforms when it comes to criminal justice systems, and the positions taken by certain critical scholars that if these structures and mechanisms did in fact come into effect, they would negate the benefits that criminal justice institutions serve to the elite and those in power, benefits that are often operationalized through informal relationships, networks, and norms. And although I approach informality as a key concept of post-colonial perspectives on policing and security work, and as I employ it in my work, I'm increasingly inclined to think that it's a concept that can travel further and allow us to include more directly not just street-level bureaucrats, but also senior state officials and public servants as crucial beneficiaries and agents of informality, because informality has constructive power, especially in the field of security and in the provision of security. So first, I want to briefly mention the idea of informalism. Informalism has been defined in legal scholarship as a means of ordering, as a form of ordering embedded in judicial and administrative institutions. It's understood as a way of resolving petty disputes in efficient and fair ways. The informal side of the law sometimes is seen as being less coercive and more effective. Therefore, informalism as applied to law enforcement is seen as building informal relationships of trust, familiarity, and shared values between the police and the neighborhood, for example. So informalism is perceived as a form of order maintenance, a way of getting people to follow legal norms without directly coercing them to do so. So if informalism is understood as a way of legal ordering, as defined in legal scholarship, informality can be approached as a more complex and multidisciplinary concept that has empowered critical thinking across disciplines, as Maryam has mentioned. So informality allows us to view enforcement and ordering work that's performed by police and security practitioners as work that is not just limited by legal definitions, legal frameworks, and not even defined by its effectiveness or efficiency or the fairness it produces. So it's allowing us to move beyond this duality of legal and illegal and allowing us to be unrestrained by reductive notions of who is a criminal and what is criminality. Furthermore, informality allows us to capture not just the behavior of private individuals and those on the margins, as sometimes urban scholars approach it in this way, but it also helps us understand how informality is actually central to official state and bureaucratic practice and can enable the police, for example, to try and meet increasing and often competing demands and the formal requirements of the state through improvisation, creativity, and the circumvention of formal barriers. Relatedly, informality also goes beyond the idea of police discretion and problematizes the idea of abuse of discretion, as discretion is typically referring to formal legal doctrinal boundaries for law enforcers or what is sanctioned by the state, while informality allows us to take a multidisciplinary approach to the practices, behaviors, justifications that are used in work performed by administrators of justice and enforcers of the law in relational ways. So how these behaviors and practices are produced relationally in terms of, for example, employee's relationship to his institution, his patron, the state, society, or even identity-defining markers such as race, religion, class, or gender, rather than in relation to the law. So instead of boundaries, it asks us to focus on relationships and identities and the outcomes that are created by these. So the Global Informality Project, for example, draws on these multiple perspectives to talk about and define informality as an umbrella term for a variety of unregulated human activities that go under the radar, stay above or beyond the law, or circumvent the law through loopholes. It refers to the world's open secrets, unwritten rules, and hidden practices of getting things done, and captures the know-how of what works in the vernacular. So in my work, I approach informality as the flexibility, pragmatism, negotiation, navigation, and the constant struggle that is required for personal survival and professional development in certain fields like police and security work. Strategically, informality is an interest-based strategy, as I call it, that in the context of police and security work, thrives on the subordination of public officers who seek out survival strategies in the face of political and security-centric demands placed on these officers by both public and private actors, and the possibilities that these demands create for negotiation, networking, and alliance-making. Such navigation, negotiation, and networking may also consist of using informal means and methods for establishing interpersonal relations and patron-client relations that may secure prosperous promotions, preferred postings, or even to just procure limited financial rewards. So in short, informality is helping us capture, in my case, the multifaceted world of policing and police work in multifaceted ways. So, in some of the preliminary findings that I'd like to share, I find that informal norms, behaviors, practices, and networks feature quite commonly in the vocabulary of police officers when they're talking about the mundane, everyday work and labor that they must perform in service of the state and its elite, and at times even the communities they serve. So when it comes to the provision of security goods and services, for example, informality becomes a mobilizer of jugaad. Jugaad, or the informal ways of getting things done, may include petty corruption, but it's more complex and nuanced. Jugaad are actions that involve quick and dirty fixes or problem solving through improvisation, especially for an institution faced with scarce resources and other limitations. Jugaad, be that in the form of petty corruption or mobilizing patronage, is something recruits learn very on the job, often at training academies. So consider this quote by a police training whom I met very early on in my research. He says, recruits are introduced to corruption at police training centers. From the beginning, they need to engage in such informal practices for recruitment, for getting leave, for getting more food, for getting time to relax. At times, to get the first and second positions for passing out at the training center, and the candidates need either a political sifarish or money. If the trainers are corrupt, how do you expect the recruits and trainees to be much different? So although there is an emphasis on corruption here, scholars who work on informality in the context of law enforcement in South Africa, Ghana, India, or Nigeria even, have suggested that we contextualize such exchanges in the context of unavoidable informality and the ethical ambiguities associated with so-called real police work. When thinking of unavoidable informality, another critical way informality is mobilized is during a time of crisis. Policing and law enforcement during the COVID-19 pandemic and subsequent lockdowns in Pakistan is a particularly illuminating example. It was during this time when I was trying to understand how the police was struggling to haphazardly implement very haphazardly drafted security and public health policies that I was introduced to another concept by a police officer, similar to jugaad. It was akhpal bandobast, literally meaning apna bandobast khud karein, or make your own arrangements. Consider this quote by a police officer who was in the field during the peak of the pandemic, during this health emergency in Punjab. He says, yes, we have resource shortages, but I also don't see police command and leadership giving much material support to junior officers. It's very much an akhbal bandobast type scene. Continuous provision of PPE is not possible, but officers don't ask the rank and file about their needs either. It's understood that the juniors will make their own arrangements. The rank and file are not prioritized. Senior cops, management need to ask about the well-being of juniors. So if you observe how policing and law enforcement services are provided during protests and processions, similarly, such as in the case of the Muharram Jalus in Karachi, for example, you are likely to witness how informality is used and expected to be deployed in routine police work. So both concepts, jugaad and akhbal bandobast, can actually help us capture informality in terms of the administration of justice, the provision of policing and security, and in the enforcement of law. While jugaad is the action, the activity, or sets of techniques used. Akhbar bandobast can be understood as the direct or indirect guidance or direction given to state actors and law enforcers that can result upon the reliance of jugaad in everyday work. The persistence of informality in police work and law enforcement is thus what helps officers internalize the fact that they need to rely on social and cultural understandings, make their own arrangements, and use innovative, flexible means to meet the demands placed on them from their own institution and their patrons. But there are other sides to informality. One that cultivates networks of patronage between police and political bosses. The other that facilitates the implementation of problematic security policies. And I'll touch very briefly upon both. So the provision of public security and patron-client relationships go hand in hand in most societies, but they are especially visible in the global south. The utilization of informality in strategic ways serves not only the one who is patronizing, but also the officer who relies upon politically influential figures and persisting politicization to strategically navigate the professional and financial constraints of the job. For instance, one of the main dynamics I note in my work with the police is alliance making, not just between junior police officers and their political patrons, but also senior police officers who patronize their subordinates for either political or financial gains. This sort of alliance making can then help both parties, both officers, navigate the limitations of their professions and operate around legal boundaries. So consider the quote above by a senior police officer. Strategic alliances or patronage are based on two things. The first is a type of relationship. The first type of relationship is work or performance. When they're transferred or promoted, PSPs often move with their own core teams. They're inspectors, tech guys, security guards, etc. The subordinates within these teams can be used for the work of their patrons because the patrons know their work can be good. The flip side to this is that those core team members are given licenses to do things that others cannot. The other type of relationship is based on money. If a PSP officer is corrupt, he will set up a line for the money to come up the chain of command, starting from the rank and file. For the good subordinates, both pathways for the subordinates, both pathways are for navigating the institution for good, lucrative promotions, positions, and fringe benefits. While this reflects alliance making within the institution itself, it's equally applicable to partnerships and linkages that are developed between officers and their patrons, especially officers who are known to be or considered to be the blue-eyed boys for certain elite institutions, both civil and military. Lastly, while in many ways informality serves the police officer and allows him or her to serve in return their patron state or society, by bypassing formal and legal constraints, sometimes those very formal and legal frameworks can in fact aid in the persistence of informal policing methods. This speaks to what I had said earlier about the centrality of informality to state and governance, state practice and governance in the global south. Consider the policies and frameworks that apply to migrants and stateless persons in Pakistan, for example. One of the things I have been interested in is how such policies, migration policies, translate into local everyday interactions between street-level bureaucrats and officers and the migrants who have to navigate these spaces that constantly put them at risk of being over-policed, underprotected, and exploited or even extorted. If we take the example of Bengalis in Karachi, for instance, many of whom have been stripped of their citizenship because of the securitization of migration and racialized migration policies, these Bengalis note how, because of such policies and their resulting marginalization, they become easy targets or easy prey of certain policing practices. On the part of the police officers who engage in extortive behaviors with these migrants, the understanding is that due to these policies, there are two things that are happening. First, The marginalized and vulnerable migrant who does not possess citizenship is going to avoid encounters with the police, because if he or she does encounter the police, he will be at risk of arrest or other surveillance mechanisms, because of which he will want to buy his way out of that interaction. And second, when an interaction does take place, exploitative behavior on the part of that officer will be overlooked by his own institution that is already tasked with the over-policing of this particular minority group. I'm happy to unpack this later, but right now I want to just mention one quote to demonstrate the junctures at which informality operates in the pursuance and implementation of certain problematic policies that do not take institutional realities and individual constraints into account. So consider this quote by a Bengali resident from Machar Colony. If a Bengali resident of Machar Colony is in possession of 1 lakh rupees and a khabri or an informant comes to know, the khabri will tell the local police wala and the police wala will pick up the resident. The police wala will say, oh look, we have found a stolen mobile phone on you. And they'll also have a witness saying, yes, he stole my phone. The resident will just want to get out of that situation. He'll say, I only have 20,000 rupees, please take this and let me go, I'm a poor man. So out of the original 1 lakh rupees that he had, he'll give some to the police and be released. From that, the police will pay a little to the khabri and a little to the witness and keep the rest for himself. So, therefore, sort of just based on some of these very preliminary findings, I'm basically suggesting that informality gives us a multifaceted lens through which we can approach and conceptualize a range of police and security work, recognizing that, like judges, whom Yasser will talk about in a minute, police officers too are relational human beings, which can help us put their varied practices and behaviors on a spectrum that I hope to develop going forward. But also going forward, I'd like to mention some of the questions that we can be thinking about further. First, what does the mobilization of informality mean for lower ranked and lower class workers of public security institutions and law enforcement agencies and criminal justice institutions? How does informality and the use of and the deployment of informality in everyday police work correspond with their interpretations and attitudes towards formal laws and formal procedures, their legal consciousness? And third, what does such mobilization tell us about police power and authority, and how does it complicate ideas around police discretion? Finally, what kind of policy-relevant analysis can we get out of acknowledging pluralism and diversity in police or security work, especially if informality is seen as a significant barrier to certain kinds of formal reforms and institutional change, but is nonetheless a key component of police society and state-society relations in the developing world because of its constructive power. So I will leave you with that, and I'm very happy to get some suggestions and comments. Thank you.
Is this working? On? Can you hear me? Okay. So thank you so much, Zoha. I'd like to invite our second speaker, Dr. Yasser Kureshi, to present his work on informality and the legal complex in the shadow of the Constitution. Thank you.
Thank you, everyone, for being here. It's a pleasure to be here today. And thank you to Maryam for putting together this panel and bringing us together to talk about these different aspects of informality and the law. And I think, as you know, Maryam's presentation explained, the purpose of our panel today is to take the study of the law and justice beyond formal institutions and bring in the role of informal institutions and relationships in shaping the actual development and implementation of the law and understanding the behavior and structure of legal institutions. And so my focus here is less sort of grassroots institution, and I look more at the superior judiciary, the high courts, the Supreme Courts, which we're so used to thinking about in terms of, you know, what are the courts doing with what vote of no confidence and what parliamentary procedure. But I think that it's really interesting to think about how judges actually are shaped by informal relations in the decisions that they make, right? And so much of the research and focus of the study of judicial institutions in Pakistan has been built around the idea of judicial independence, right? So it's a field overwhelmingly dominated, I think, by legal professionals and legal scholars who are so focused on the study of formal legal rules, constitutional guidelines, and statutes that provide these formal guarantees. But understanding and designing an effective judiciary requires paying attention to both these formal rules of institutional independence and authority, and the informal relationships the judiciary builds with state institutions and society. Because judges are embedded in social and professional networks, and the influence of state institutions over the judiciary is not restricted to formal mechanisms of control, but also involves influence through informal relations between judges and elites in state and society. And so the questions we need to be asking about these formal rules is not simply, do they protect judicial independence or not? Because there's never an either or. It's more important to think about how different rules and structures privilege different kinds of relationships, formal and informal, between the judiciary, between judges and elites in the state, in society, etc. Right? So in my presentation today, I should move forward. Yeah, that was what I was going to say. Sorry, sorry about that. But in my presentation today, I'm going to discuss a framework for understanding judicial behavior by trying to embed it in these professional networks within judges sort of emerge and from which they continue to interact with as judges, and understand the ties that connect judges informally to other elites in different networks, both inside and outside the state. I'll be synthesizing some insights from my own research for my book, as well as for a paper that I'm working on with my fellow panel members over here for a project we're trying to do together. And so the goal of my presentation really today is primarily descriptive, to outline the important nature and types of informal relations, particularly between judges and lawyers, and how these, what these relationships look like, and unpack them, and then consider at the end how understanding these informal relations can help us better understand some of the important phenomena in judicial behavior that we are so interested in understanding today in Pakistan's current political context. So let me first introduce my framework for understanding the relationship between the judiciary and the networks judges belong to, which I call the audience-based framework. At least that's what I use in my work. And audiences, for the purposes of this discussion, could be political institutions, political organizations, or social and professional groupings that are attentive to the decisions that judges make, and among which judges have reasons to build their reputations. So why do judges care about their reputations? What are we talking about here? Well, reputation building has both material and non-material purposes. Reputations are what we understand to be the stock of assessments about an actor's performance. How good are they as a judge? How good or not good, right? Now, this has purposes materially, because materially, judges seek to advance their careers, and having a reputation as a capable or able judge will obviously have important benefits for advancing their careers, their promotions, etc., right? But beyond that, also non-materially, judges also seek to build their reputations as able judges to gain the esteem of the professional networks they are closely tied to, as their own relationship to their job, their own esteem is tied to gaining that respect, right? So they will seek to build their reputations with the groups and networks with which they have been socialized and which they identify with or interact with frequently, right? And these networks from which judges are recruited or which they continue to interact with often set the norms with which judges feel the need to comply in order to build a reputation and gain esteem. And the judiciary is typically recruited of any state from one or a combination of sections of what Maryam helpfully explained as the legal complex, right? Which is the cluster of related legal actors related to each other in structures, and includes, as Maryam said, private lawyers and prosecutors, judges, legal academics, civil servants acting in legal roles, etc., right? And so for each question, the question is, which section of this legal complex are judges recruited from? In what are called closed recruitment systems, judges are typically recruited from judicial bureaucracies, and in open recruitment systems, they're recruited from outside the bureaucracy, often from the legal profession. And these are the networks then, right, from within the bureaucracy or from outside in the legal profession, that judges train, work, and socialize with both before becoming judges and continue to even after becoming judges, right? And these networks have played a critical role in shaping often judges' ideas and norms of what are acceptable and unacceptable actions for judges to take. And so these professional networks, therefore, are salient audiences with which judges seek to build a reputation. Judges will, in their decisions and actions, often consider the preferences and ideas of these audiences, and especially with the actors and institutions best positioned to shore up their reputations with these audiences. So when we ask which judges have developed a reputation as a good judge or an able judge, deserving of promotion or deserving of professional esteem. The question isn't really an objective one. For the judge, it really depends on who the audience for that judge is. Who do they care about? Who is salient for them? And what are their expectations, norms, and preferences that we have to consider? So that's what I call the audience-based approach. And let's think about how that plays out in understanding relationships between judges and their audiences in Pakistan. So again, I forgot to move slides forward. So this is what I just said right now about closed and open systems and the legal complex. So yeah, I will move on. So on to Pakistan. So Pakistani judges are, as we know, typically in the High Court and Supreme Court appointed laterally, with at most 1/3 of High Court judges appointed from the lower judiciary, the judicial service, and at least 2/3 of High Court judges appointed from the bar of practicing professional lawyers. It's interesting to note, before, in the 50s and 60s, there was a large number of judges who were appointed directly from the civil service, along with the provincial judicial services. But since the 70s, late 60s and 70s onwards, the majority of judges have come from the bar, from the professional lawyers and practicing lawyers. Thus, Pakistan is a state where external audiences outside the judiciary matter a considerable amount for judges. Let's think about that a little further, right? Because if let's first talk about the ways in which the external audiences matter, right? Both for material and non-material reasons. Well, firstly, let's think about the non-material reasons, right? Judges, as I said, care about how they are viewed within their networks. And let's think about how important these professional networks of lawyers are often for judges, right? Judges typically are appointed, the minimum age of appointment of a High Court judge is 45, right? So that means you typically become a lawyer, you become a practicing lawyer probably at the age of 21, 22, right? So that means you're spending about 20 plus years in the legal profession, moving up through law firms, through bar associations, building networks, ties, and moving up that system and building a reputation in that system before you become a judge. So that's 20 plus years you spent in the profession, training, socializing, interacting, and these networks stay with you even after you become a judge. And then typically you retire at the age of 62. Now most judges want to go back to practicing again, so they go right back to the profession right after that, right? So therefore they really care about how these networks see them. As one, I was at this rally where these lawyers were sort of protesting against some judges' actions at the Sindh High Court bar, and this was one of the speeches that the lawyers made, saying, what were these judges before? All these judges were lawyers first here in the bar, we enrolled them, and gradually with our help they became judges, and when they retire, they will come back here to us as lawyers. So they really need to care what we think, right? And that was kind of the idea of some of these, within the bar, about how judges, why judges matter so much, or why lawyers at the bar can matter so much to judges, right? And that goes beyond just, their sort of this relationship, prior professional relationship and post-career professional relationship that is sustained. It's also to do with the power that bar leaders in Pakistan have, right? So increasingly bar leaders in Pakistan have become powerful figures and bar associations have developed a repertoire for commending judges who uphold their preferences and interests, and for criticizing, chastising, and indeed mobilizing against judges who don't, making going against the interests of the bar often quite costly for the reputations of judges. So with the proliferation, for example, of media, judges have grown a lot more concerned about their self-aggrandizement and they care about how they're projected. But judges don't often, appear before cameras and TV shows, etc. And so often for judges, the primary spokespeople are these senior lawyers who appear on television channels, who appear in public to discuss the decisions of judges, their actions, elevating their importance, and often they are bar leaders in shaping the esteem of judges with their social networks. I don't know how many times we've seen, bar leader from Islamabad or Lahore sitting on TV, on Geo or ARY talking about some decision that judges have made. And this matters to judges. They're noticing how they're being talked about. As a senior judge explained to me, the bar was the loudspeaker of the judges, as he put it, right? Third, as I think I mentioned, the bar has the capacity to mobilize the bar. Bar associations are growing institutions, and the sheer size of bar associations with lawyers filling up with young lawyers, often with few employment prospects, are seeking to become this ready-made cadre, actually to use the language Sarup Ijaz here used in his own work here, which influenced my own work, a ready-made cadre of sort of ready-made protesters who can come out on the streets and anytime to protest and carry out the stance and mobilize on the stances of bar leaders in Pakistan. And we saw this to devastating effect and consequential impact in the lawyers' movement in Pakistan. I was going to mention Maryam's work on the lawyers' movement, which has influenced, and how that mobilization was carried out, which has influenced a lot of my own research on this topic. So we are very familiar with this. And I'll give you one other example also. This was in 2002 in Pakistan. There was General Musharraf had recently just instituted the Legal Framework Order, right, which was a constitutional amendment package. And at this time, a number of major bar associations in Pakistan had seen elections won by leaders who were particularly critical of the Musharraf regime. And what they were doing was this platform developed of opposition to the regime. But their opposition wasn't limited to the regime itself, but also towards judges who were seen as collaborators with the regime. And judges who cooperated with the regime were not spared. So you have the Supreme Court Bar Association publicly protesting, accusing the judges of the Supreme Court of sharing power with the military rulers, for which it was apparently being rewarded, and saying it would not argue any constitutional matters before such a compromised court. The Pakistan Bar Council then also released a white paper on the judiciary, which called out judges who had, quote-unquote, bad reputations, and discussed corruption among senior judges, and named and shamed judges for upholding the powers of the regime. So what were the bar associations doing here? They were exercising their power over the reputations of judges to pressure them into acting in line with the preferences of the bar. Now, this is not to say that the organized section of the bar only influence or exercise influence over judges purely for the sake of upholding good values and democratic principles, right? But also for influencing judges to shield lawyers and bars from accountability. So one of the biggest questions we keep asking in Pakistan today is, why don't judges ever hold these lawyers accountable for Vuklagardi and other things like that? And one of the reasons of this impunity is these kind of concerns judges feel about how the lawyers, how the bar leaders see, interact with them, can mobilize with them, can damage their reputations, etc. But what's important here is formally, bar associations can actually do little to make judges suffer for taking these actions materially, but it's all about making them suffer reputational costs. Judges don't face elections, but they care about how their networks view them, observe them, and think about them. But now, even moving beyond the non-material to the material, right? So when judges are appointed, members of the professional network, we also need to consider how these formal appointment processes can, in different ways, privilege voices within the legal profession in the process of appointments, promotions, and confirmations, right? So before 1996, the system of judicial appointments was highly executive dominated. It was a conversation between judges and the executive branch and a negotiation, but the particular preferences of the executive held sway because the president was the final decision maker in this regard. But from 1996 onwards, at least, the formal appointment process made the view of the Chief Justice at least formally binding on the president regarding judicial appointments. What this meant was that it remained a negotiation even after 1996 between the judges and the executive branch, but the Chief Justice's role grew in this process, right? So after 1996, the Chief Justice's advice became at least formally binding, making it harder for the president to reject the Chief Justice's choices. So you still had negotiation, but judges and executive officers were now unlikely to propose or shortlist candidates that the Chief Justice was likely to reject. And the Chief Justice thus had more say in this process. This sort of increasing role of the Chief Justices in the appointment process is further consolidated in 2010 after the 18th Constitutional Amendment with the creation of the Judicial Commission to nominate, to appoint and promote judges, and this role in which sort of really gave the Chief Justices of the High Courts and Supreme Courts a preeminent role in the appointment process and consolidated their power over it. Now that's the formal story, right? But the informal story here is also, as we know, that there is no real meritocratic system of judicial appointments in Pakistan formally. It's an opaque process without clear rules and criteria for appointment, giving considerable discretion to the primary appointing authorities in making these selections, promotions, confirmations, etc. What this means, therefore, is judges will consult or speak to those who are close to them. And these judges typically were former lawyers themselves at the High Court or Supreme Court. So they often start speaking to those lawyers, whether it's the law firms they belong to, the members of the law firms they belong to, the bar groups, the leader of the bar groups they were close to from where they heralded and from the maintain other ties, government lawyers, etc. So these voices, these informal voices, are privileged further in the appointment-making process informally by the growing centralization of the appointment process in the position of the Chief Justice in Pakistan. And thus, this actually gives certain bar leaders and certain law firms and legal elites an important role. And for people trying to become judges, trying to get promoted, trying to get confirmed, reputation with these legal elites informally becomes very important. Remember, there's no formal power here, but that proximity, that informal relationship with these judges gives them that role and that salience as an audience for any judge looking to move up the career ladder, right? And there were some judges I spoke to, and lawyers talked about this, right? Leaders of the bar associations explained to me, judges would always often consulted us and members of their former chambers when they were considering candidates for judgeships. And another former Supreme Court judge explained to me, reputation in the bar is very important. You cannot hide your conduct from from bar leaders. Problems can be created for unwanted judicial appointments, disruptions in the court, whispering campaigns against these judges. I've seen this happen as a judge. So these are the tools and tactics that bar leaders and legal elites can use to see those judges who they'd like to see move up the ranks, move forward. And it's important, therefore, to build your reputation with these figures as well. Thus, both for material and non-material reasons, judges' actions are shaped, therefore, by the interests of these legal elites and lawyers in the professional networks. Now, this is not to say that the bar is the only informal relationship that matters, by no means. It's just what I'm focused on in this paper and this discussion. Judges actually will vary, will vary significantly in terms of which sections of the bar and legal profession and consequently which members of the legal elite they value. For instance, judges may be coming from one bar group, may value those preferences compared more than those of the preferences of another bar group. Judges also maintain relations with other elites inside and outside the state. As a senior lawyer once explained to me, 2 minutes? Great, yeah. That works. Once lawyers become judges, particularly when they become senior judges, they interact more with senior state officials as well, bureaucrats and military people, and this influences them, right? So the senior lawyers are by no means the only important audiences, and many judges may remain closely engaged with legal professionals within sections of the bar, but some will gravitate more to state bureaucrats, party politicians, and military elites within the state. Therefore, judges vary in terms of the sections of the bar, sections of the legal complex they deem salient audiences. And to really understand the behavior of many of these figures, we need to think about which audiences different judges deem more or less salient in their careers, in their lives, etc. Right? And last, therefore, what I wanted to mention is when we talk about today in Pakistan, we're really interested in the rise of populist courts and populist judges, etc., right? And this is something, I try to explore more in my own work and in my book. But one thing I wanted to point out, to really understand that emergence, it's really interesting to go back to these relationships between the bar and the bench and the importance of the bar and some of the conversations and discourse happening in the bar, especially in the 1990s and early 2000s, where sort of these ideas about courts acting and treating the rule of law as a spectacle really emerged. There's some fascinating moments like bar leaders jumping into the cages of lions to demand at the zoo to demand that judges should be to demand that politicians should be held accountable before the courts, right? There's this really idea that rule of law is a spectacle, and we need to see, rather than a conversation about procedures, institutions, processes, it was all about spectacular assertion of judicial power against corrupt politicians and corrupt elites, and the use of suo motu powers, etc., against such judges. And I think we really see that taking off in the 90s, and we see that in the bar, and thus I think understanding the informal relations and interactions helps us understand how that percolated from the bar to the bench in the 2000s, right? I will leave it there. We can discuss and unpack that further in the Q&A or after as well. But yeah, thank you so much, and we can move on to the next. Thank you.
Angie, Thank you so much, Yasser. Anything to do with lawyers and judges is usually so interesting, but that was scintillating. Thank you. We move on to our third speaker, Palvasha Shahab, who will today present her work on swift labor extraction, protracted denials, strategic omissions, and miraculous non-accidents. Do you know what this is?
Assalamu alaikum, everyone. I apologize for the
Does she
nasal
have-
tenor of my voice today, but nevertheless. So what I want to talk about today is that, for most parts of Pakistan, but since I work mostly in Karachi itself, it's very well known that there's no regularity in any kind of factory or workplace inspections, right? There is a very comfortable knowledge that whether it is legal conditions of employment or safety of the building construction, etc., these go unregulated by and large. Yet, if one were to look at the level of deregulation, one doesn't see as many accidents as they would expect. So I've been working on occupational health and safety in one form or the other since 2013-14, and every time I've gone into the field to do research, I've come back with more or less some version of the same story, that there's no human resource, the law is not implemented, there are policies in place in order to satisfy forces of global capital, which require that regular inspections and conditions of safe work not be met. Fair enough. But if one were to look at how there aren't more frequent stutters in then these chains of value production, and how labor extraction remains swift and cost efficient, we wonder how this is happening, right? So if one looks at just the kind of history that has created this lack of regulation or lack of inspection, in 1986, the ILO Review Mission on Health and Safety said that going by the current capacity of the inspectorate, a factory inspected in 1986 would only next get its turn for inspection after 30 years. So how have we survived so far? And in addition to that, a more recent interaction that I had with the former deputy director of the Department of Labor and Human Resource of the government of Sindh, I asked him, 2 years ago we had a conversation. You said there are 17 factory inspectors for all of Sindh. I'm just wondering if there's been any change on that, and if there has been any additional hiring of inspectors. And he says to me, yeah, well, 2 of them retired, so you count 2 less. And this is essentially how things have been going. Now, I want to use, so just to actually stop and give a quick roadmap of how I want to proceed, and then I'll identify 3 key points of departure for inquiry in this particular project for me. So I'm going to talk a little bit about the present conditions. Then I'm going to talk about my methodology, the analytical framework of informality that we're going to be applying, the kind of practices that are presently animating labor extraction, the moves away from the regulated workspace that further frustrate any formal laws or departments that may be attempting to regulate labor extraction, and then the kind of strategies that have been adopted for bare survival, really. So in exploring these ideas, the kind of miraculous non-accidents that I'm talking about, or the sheer befuddlement that people are not popping dead or grievously injured more often than we already see them. I'm going to depart from 3 instances. Pehli, there was a 3-day-long fire in 2016 at the Gadani shipbreaking yard. MT Aces, a ship that was of Japanese build had beached at Gadani on 22nd October 2016, and an explosion on the very first day of its breaking cost, I think, sorry, I'm just going to, 28 lives and 58 were grievously injured. Now, what I remember particularly from the days immediately after the fire is the stench of burning skin when I visited these workers from the shipbreaking yard at the Civil Hospital Burns Unit in Karachi. And I remember thinking, how is this possible? Of course, I was much younger then, and a lot more idealism was at play. Now I know that it's unfortunately very possible and quite regular. The second thing is the Ali Enterprises factory fire of 2012, on which I didn't start working until 2018. But of course, I'd been following the kind of events that had been unfolding. And in both of these fires of 2012 and 16, one very salient feature was, now the Ali Enterprises factory fire is situated in site area Karachi, which is an export processing zone essentially. And of course, this ship that had exploded had come into plot 54 of the Gadani shipbreaking yard, and a ship itself, of course, is not something that's easy to hide, right? So both of these fires had occurred in places where no registration, no NOC, no approval had been granted to the body that was doing this work. In the Ali Enterprises case, the factory was not registered, not with the site authorities, not with the labor department, not with they didn't even have approvals from the Sindh Building Control Authority, right? In the case of the shipbreaking yard, this ship had not gotten its NOCs from the Balochistan Development Authority, not from the Balochistan Environmental Protection Authority, and not from the Labor Authority either. How is it that these giant operations continue without any kind of registration or approval or sort of even mere recognition by government departments? The third instance that I want to talk about is litigation that we conducted at the Sindh High Court on the non-payment of minimum wages for the janitorial staff of the cantonments in Karachi. This includes the Clifton cantonment, the Karachi cantonment, the Malir cantonment. And just to sort of provide the basic information here, these are, of course, military cantonments, and janitorial staff is hired as through third-party contractors, and none of them were receiving any kind of regular letter of employment, minimum wage, etc., as is the way of working in Pakistan or in Karachi for that matter. Now, in terms of methodology, I'm going to come back to these three instances that I've just mentioned. In terms of methodology, I've relied on court records, on government documents, on ethnographic interviews, and on news reports. The reason I mention this is because this is stuff that I've been building on or working around for a bunch of years, and this also involves in large part a lot of field notes from the work that I've been doing myself as well. If bits of information seem anecdotal, please do feel free to stop me and ask me where I'm coming from in a certain respect. Now, coming back to the three instances that I started thinking from, and kind of building towards how is it that building towards the question of how is it that more accidents are not happening? How is it that more deaths are not happening? How is it that more people aren't being denied minimum wage? If I were to look at all of these three accidents, I feel like a large part was played by the kind of public discourse they created, and by the kind of threats they posed to lower level bureaucrats, lower level inspectors, etc., as well as to the owners of these respective enterprises, right? So what they did was that they indirectly inspired, for example, a lot of self-regulation. Because they didn't want to be the next ones in the news. So a lot of enterprises started self-regulating, and this is something that, in fact, is not new. I mean, if you look at the US history of the early 20th century, you see very similar self-regulation when more and more accidents get reported or big accidents get reported. A lot of enterprises start self-regulating. And a lot of these enterprises seek the help of regulatory authorities to kind of give them the lower threshold and promise to look away once the lower threshold had been met. So in a very similar respect, for example, after the Ali Enterprises factory fire, or the Baldia factory fire as it's more commonly known here, you know, the Sindh Labour Department had only 7,000 factories registered, and an additional 2,000 registered within the next 2 months. As soon as the High Court proceedings started, as soon as the factory fire started getting more and more traction. Similarly, with the shipbreaking yard, as soon as this fire became big news, ambulances which had not been present at the time of the fire, ambulances that had gone all the way from Karachi to collect these victims of the fire, were now permanently placed at the shipbreaking yard. Protective equipment was suddenly present a month later at several plots across the yard. There was a lot more stakeholder consultations, a lot more conversation with the workers about what kind of basic safety they needed. And a lot more congeniality between the labor department and their inspectors and the enterprise owners who were working at the shipbreaking yard. Similarly, in the case of the minimum wage litigation at the High Court of Sindh, you see, you know, for the first year or so, the High Court doesn't take our case so seriously. We go, hearings happen, you know, next hearing, next date, etc., etc. At one point, one of the judges becomes really interested in our case, and we're finally able to get through to them. And suddenly, it's coming in the news, and we start getting testimonials from workers we've been working with that we are now being paid minimum wage. There's no orders at the High Court yet. The only thing that the High Court has required as yet is more information. But minimum wage is suddenly paid. And, you know, and not only paid, from the most recent notification, even though there was time yet to operationalize that one. So in these instances, or in these moments where one sees how not actual implementation of the law, not actual work done by those who are required to implement the law, to do the requisite approvals and inspections and so forth. In fact, in the case of the minimum wage litigation, that the minimum wage board hadn't even been populated yet. So there wasn't even recourse for the workers to come and say that they're not being paid minimum wage. In all of those absences, you see that you know, certain minimum standards suddenly start getting maintained, or there are moments where they're doing better than at other times. So in going forward with this project, I'm as yet, I mean, it's a working draft, and I'm trying to conceptualize how one would look at these instances where it's not the actual law, it's not the actual bureaucracy, but it is the conditions, the political milieu that is kind of forcing certain safety standards. Of course, in conversations with, you know, officers of the Labor Department, I've also noticed that ethnicity has a big role to play. You know, certain tasks are done by certain ethnicities, and if those ethnicities are mirrored in the Labor Department, then there will be a lot more sympathy, or a lot more interest in keeping those lives safe. You know, kinship, zaat, etc. Come to play a role. Of course, the very lowest rungs of the bureaucracy also socioeconomically find themselves close enough to the working class, and there is a certain basic level of sympathy there as well, as opposed to, for example, a director of the labor department, etc. So all of these relationships are definitely playing into when an inspector is looking away and when an inspector is doing a spot check just to be safe, when he knows he can't do a regular inspection, or when he's really doubling down on ensuring an implementation or ensuring an inspection, etc. And these are the thoughts that I want to develop as I go forward with this project, but I'm only here so far, and I'm looking forward to your thoughts and comments on how one takes this forward. Thank you.
Thank you so much, Palvasha. Just a couple of quick comments before I open the floor to questions. So thank you, because when we do law scholarship, law work, law research, we're oftentimes not accustomed to thinking of bureaucracies within that structure, right? Especially when we're looking at interdisciplinary work, law and society, we tend to kind of gloss over, more often than not, the role of bureaucracies, regulatory authorities, government departments, even though, interestingly, they are the primary infrastructure through which implementation and enforcement happens. So thank you so much for bringing that into sharp relief, and also the fact that a lot of times what you're seeing as an outcome of a certain law or policy is really, all these practices that are happening in the interstices of the social, the economic, the political, and of course legal, but legal only being one part of it. So I just wanted to sort of say those few words to sort of synthesize some of my thoughts. But I'd like to, in the interest of time, open the floor to questions and discussions, and maybe we can take a cluster of questions each time. So maybe 2 or 3 questions. Please go ahead.
So Yasser also mentioned like the rule of law is a spectacle. So I'm wondering how this new analytic in this, when you're thinking about it in this way, how do you think about formalism, and how does it change how we imagine formal law and those formal structures? And it'd just be great to get everyone's thoughts on that.
Sure.
So, a question for Palvasha. How the 3 examples that you gave, you said that in a few weeks there was a response. The question is that a permanent response? Do they go back to the old standards? Are the ambulances still there in Gadani? Is the minimum wage, which has been revised, being adjusted accordingly? So is it just an immediate, knee-jerk reaction, or is it a process?
One more. Thank you.
I just have a tiny question for Dr. Zoha. So when we talk about informality, and especially in the police department, how important is it to look at gender? Because a lot of channels for informality are more accessible to men, for example, corruption. So thank you.
So can we take these 3
Sorry,
questions
can you repeat
first?
the last second half of the question? To look at gender and something to do with corruption, sorry.
Yeah, just that, how a lot of channels for informality, for example, corruption, are more accessible to men.
Okay. Shall we go around? So first question, anybody who wants to take it? About rule of law and the imaginings of formal law. How does all of this change that or shift that?
Maryam, would you like to go also?
No.
I was just going to say, you could also go for it.
No, absolutely not. No. Maybe at the end.
Okay,
Please go
sure.
ahead.
I can start.
You can start then I'll come.
Yeah. So, I mean, I think it's a really interesting question about sort of, we were just having a discussion yesterday about how do we understand, in talking about informality, where does formality fit into our conversation? And I think that, I think it's in 2 ways. One is what we want to understand is how formal rules are actually being subverted or implemented, or actually what is, I think what we're discussing, the gap between the rule and the actual experience of the law, or the experience of that rule for people, because of how it is subverted by particular informal customs, norms, and institutions that are present through which those rules are actually implemented, and the distortions that happen as a result of that interaction between the formal and informal. So that's one area in which we do consider formalism. I think the other place which I was also considering is formalism as almost a rhetorical device for actually very informal sort of ideas and preferences, right? So the idea, for example, as you said, like what I was saying, rule of law as a spectacle, which is that I want to enforce the law, which really means I want to see a politician hung, right? That's what it is, right? A corrupt politician must be given punitive judgment, so punitive populism as it will, which is very much all about departing from formal law and formal procedure to do something spectacular, but a spectacular assertion of justice, right? So there's two ways to think about, I think, formalism there. One is the spectacle, and the other is the sort of interaction between the formal and informal, and I think we'll try to engage with these in our work.
Yeah, and I just to add, I think it would be too simplistic to kind of separate the two as not sort of operating together. I think they do very much go hand in hand. I think in the context of sort of what's happening on the ground, like on the streets, in the police, etc., for example, it can be a very interest-based decision sometimes, when to apply the law and when to refrain from applying the law, which is why I think both kind of work in tandem, especially within the enforcement of the law, and I know discretion kind of overlaps here as well. But yeah, I think that's why it is a bit theatrical, and it is a bit sort of, can be a bit ad hoc also. So I think there's a very sort of intimate relationship there, and you really can't separate the two. That's all I'm going to add here.
Palvasha, do you want to add anything?
I was just going to say, there wouldn't be an imagination of informality if there wasn't the formal law, from which one was diverging. And to Zaidi Saab's question, so in our experience so far, it seems like it is a case of 2 steps forward and a 1.5 step back, sort of. and while one takes relief in that half step that was in the forward motion, of course, this is something that is not happening in any kind of linear fashion. कहीं वो ambulance अभी भी खड़ी होगी और शायद परसों ना हो. I know for a fact that the protective equipment is still there, but I know for a fact that the ambulance is not. So these things have their own way of then going forward. What I do want to stress in this moment is also that the way that formal law in Pakistan is legislated is designed for non-implementation. So it's only there as some kind of aspirational tool or as a rhetorical tool, like Yasser said. Because if you just look at these 15 poor inspectors in the Sindh department, and if you look at the number of laws and different acts that require their own inspectors, for example, the 2017 Occupational Health and Safety Act requires its own inspectors. The Factories Act requires its own inspectors. The Sindh Building Control Authority requires its own inspectors. SITE requires its own inspectors. None of these exist. So in the absence of that, one has to, I suppose, take some relief in these half steps forward.
So can I just make a quick comment
Yeah,
regarding formal law? Now I can come in. And I just wanted to say a very interesting question. Thank you, because it helps to illuminate certain ideas. So I think here in Pakistan particularly, we look at formal law as very authoritative, very sort of autonomous in some ways. That's also been the way that historically and even now we tend to teach law. Our pedagogy is really all formalism. And then you realize when you start digging into practices and you try and understand why the outcome never seems to align with what the law really intended, you realize that, ultimately the formality of the law is going to be contingent on power, customs, norms, whatever it is that is defining your local conditions. So in my work, for instance, in constitutional design, I always ask the question, can we please first interrogate power? Because the Constitution is at a level of public power where power has to be interrogated in any sort of analysis of constitutional implementation. Of course, design matters, rules matter, texts matter, but when people say, let's tweak the text, maybe if we were to take out this language, put this in, the outcome would be different, but I'm very skeptical of that because ultimately, in so many issues across the board, it's going to be the practice of power which is going to determine the outcome. And of course, that is always contingent because there will be phases and there will be windows of opportunity where the design will matter more than the practice of power. So I'll just stop there, but thank you so much. Zoha,
Yeah.
you had to say something about gender, right?
Yeah, that's a really good point about power, and I won't build on that because then we won't have too much time. I think gender would be a very interesting sort of component to bring into this conversation, especially on power, as well as this idea of informality and where sort of, let's say, female officers, come in. It works in a number of ways. So there can be very organized networks of officers that are engaging in some form of, let's say, whether it's like a patronage network or whether it's a network of sort of corruption for a particular time. It can restrict female officers. You can be sort of, barred from that. But what it can also do is that I think if female officers find ways of working around these networks and finding other ways of engaging in informal behaviors and practices, the labeling then that is attached to female officers can be very different from the kind of labeling that would be attached to male officers. So for a male officer, again, power dynamic comes in here. A male officer would be seen as a very effective officer, right? Because he's producing results. Nobody really cares about whether it's on the, by the law, on the books, etc. As long as he's producing results, meeting the kind of demands, informally or formally, nobody cares as long as the work is being done, right, in return for any kind of payments or interest or whatever it is. If he's doing dirty sort of work to get ahead and get things done, he will get a certain kind of praise. But a female officer, depending on her rank, at least in the case of Sindh, may be then looked down upon because she's dirty in other ways, So in my experience, in some cases, for example, there was a certain affiliation attached, like ye to massage parlor wali SHO hai, for example, right? That she runs massage parlors essentially and takes money on the side. But if a male officer was doing that, that would be routine, right? It's just a little sort of, petrol business, a little, ready wala, etc. So that's how gender kind of plays, and the labeling is different, and the way their performance is perceived in the way that they engage in informal practices, and what performance they deliver from that would be perceived and measured very differently, if that makes sense. But it's a good question and lots to unpack there.
Thank you. G, let's have another 2 or 3 questions. G, Moin Saab.
My name is Muin Afzal. I'm on the board of Ideas, but in my very early public service, 60s and 70s, I dealt a lot with the police. So my question is really directed at Ms. Zoha Waseem. But I dealt with the police in East Pakistan and the Punjab, not in Sindh. So it was interesting to see that while some things have remained the same, some things have changed, but for the worse. Now, you see, in Ideas especially, but in most of these public policy discussions, we are looking at also the ways of maybe making a change for the better. Does your work take you in that direction? And if so, it'd be very interesting to hear your views. Thank you.
Ejaz from Nust University. My question is from Palvasha. In 3 cases that you shared, have you seen the official inquiry reports, their findings, their recommendations? Having served in government, I know that SOPs are revised based on these recommendations and findings.
Thank you. So, yes, thank you for sharing your work, all of you. I learned much. I guess this is a question, but also an invitation to think. So I guess my concern is, do you think that there are ways in which we can put more pressure on conceptualizations of informality so that the risk of flattening very different sorts of violations of the law or experiences of, what the law looks like in everyday life, etc. So that we can do justice to those variations. And I think, like, for example, one dimension along which this became clear to me, and I'm thinking of, the range of presentations was the question of criminality. There's, like certain kinds of, for example, informality, which is just very, very clearly criminal. So I'm just wondering if our conceptualizations can help us hang on to that, hang on to the very different stakes. Thank you.
Do we have more questions? Maybe we can take one more and then, yeah, thank you.
Shukriya, thank you for a fantastic panel. All of you spoke very well to a topic that is close to my heart, on the alternate rules of engagement that people make up themselves and everybody knows what they are. Fantastic. So my question is for both Zoha and Palvasha. Zoha, what do you think is the scope of unionization, let's say, among the rank and file of the police officers as a, what do you think good and bad can come out of it? And Palvasha, what do you expect, what's your narrative from the laborers themselves in terms of their networks and how they share information on these factories and what's good, what's bad? Thank you.
Is it the scope of humanization?
Unionization.
Unionization, that's a good question. Yes.
Angie, please go ahead.
So so I'll start and I will take both the last question and the first question, because I think because both are kind of talking about each other. It's very interesting that there aren't unions, although there's a big debate even in the West on what the unions can do, right? And how they can actually backfire when one is trying to reform institutions within the criminal justice, right? So I don't see any scope right now, but I do think when it comes to, for example, making some sort of change, as the first question was talking about, there would be an interesting addition, at least because I see in the case of India, for example, historically, and this is the work of Beatrice Jorigwe that I'm looking at, the unions did have a particularly significant role in again, linking back to the humanization part of it, which I think is really interesting when we think about change in the police and what is my work kind of talking about. So in my work, for example, this may be a little idealistic, but I do engage very critically with the way the structure of the police is designed, in that the PSP cadre is distinct from the rank and file. It's not a perfect criticism, but I think it's a way of looking at the way class distinctions within the police are sustained, and certain forms of informality which would overlap with criminal, which is Myra's question, and I'll come back to that in a second, how certain kinds of practices are enabled because of those class distinctions between the rank and file and the PSP. And what kind of, again, how it enables certain kind of alliance making, how it creates possibilities of, patron-client relationships and all of that. So, and I think that happens, that kind of alliance-making, networking, patronage happens because they don't have the option of unionizing. So because that external protection is sort of, as laborers, that is not given to them, they then turn to these alternative means of networking and seeking protection for themselves individually, professionally, even physically at times. So I think when I talk about change, that is one of the things that I do propose, is that we rethink the structure, which I do suggest is very idealistic, because that is kind of going back to the way it was pre-partition, because during the colonial period and the way it was designed. But I do think that that is the first thing that we should be looking at, is critically investigating the way the structure is designed and the hierarchy of the institution is designed. So I'll stop there, and then we'll come back.
So I'll answer your question about reading the investigation reports, and then I'll come to your question. So as far as the investigation reports go, for the Gadani shipbreaking yard fire, I wrote the fact-finding myself, as well as engaged with the investigation reports of the Labour Department and the Balochistan Development Authority, as well as BIPA, which is the Balochistan Environmental Protection Authority, as well as the Ministry of Shipping and Maritime. With the the Ali Enterprises factory fire, there was one report by the FIA and another by the police and yet another by the Labor Department. While there were some changes in SOPs here and there, by and large, they were cosmetic. And the one big, piece of legislation that was hailed as a response to particularly the Ali Enterprises factory fire was the Occupational Health and Safety Act of 2017, of which the rules came like a good 3-4 years later. And incidentally, the rules spoke primarily about the cotton and textile industry, cotton garment and textile industry, because the Factories Act of 1935, which had been in place in the Indian subcontinent at the time of partition, was an iterative response to something that had been pushed by the Manchester Cotton Union in opposition to the demands of the Indian Mill Hands Association. And we were still stuck in that paradigm. And इसीलिए जो occupational health and safety का कानून बना, जो एक cotton industry पे limited नहीं होना था, उसके भी rules में ज़्यादातर बात cotton textile और garment की हो रही है. तो ये, I mean, I'm just trying to highlight the kind of, legislative mindset or policy making capacity that we're working with. And in response to that, thank you for a very interesting question. Actually, when we were investigating the Gadani fire, we realized that different tasks within the industry were very ethnically divided. So for example, the gaslight workers were invariably from KPK. The sludge cleaners in the ships were invariably Bengalis or Rohingyas. And this is something that you see, this is a trope that you see across the board. If not ethnically constrained, then constrained by perhaps a neighborhood or by an industry. And there are very strong networks of communication that run from the rural to the urban, and in fact sometimes even globally. For example, workers that go and work in labor camps in the Middle East. There are chains that go from a village in Swat all the way to Riyadh. And these are the networks that really, carry all that information. These are really the ones that most regulatory authorities are also aware of. And they know when to tap into it. As far as, I'm sorry, I'm just going to also respond a little bit to your question. As far as criminality goes, there was talk of investigating both the owner of the shipbreaking yard plot and the Ali Enterprises factory fire criminally, and there were criminal charges filed. And these respective factory, in one case, they put the contractor in front, and the poor contractor was the one who got criminally investigated, and the other case, the Bhalla family basically absconded the country. So, I mean, whether it is the criminal justice system or whether it is any other laws, they're equally, inept to respond to our lived realities and the conditions of labor extraction and work. So I feel like while, sure, it is very important to call something criminal, it may not necessarily always give the kind of results that we are expecting.
Thank you so much.
I quite like the way you sort of framed that. And when we think about sort of labor extraction and workers, etc., I think there's increasing amount of literature that's looking at sort of police and private security guards, police workers, etc., as also providing a certain kind of labor and also being exploited and extracted as a result of the kind of labor they provide. But I do like the kind of, the push on conceptualizing informality better. And I think I've gotten that in sort of other work as well, because I do think that there has to be clearer but it's clearer distinctions made, but there are always going to be certain overlaps. I do also sometimes think that when you think about crime, criminality, and criminalization, we're bringing in again the legal and the formal, and sort of thinking about certain behaviors through very sort of formal doctrinal ways. But we're not thinking about, as Palvasha was saying, the conditions and the conditionalities in which certain work is performed. So that's why I feel like when we're thinking about the relationships in which certain behaviors are taking place, or the kind of social and political reasons that are leading to certain kinds of informal behaviors and practices, then maybe informality can be one of the lenses through which we approach certain kinds of and certain forms of practices and behaviors. But it could always certainly be a spectrum, as we're thinking about sort of maybe that is also one way of looking at it, a spectrum of sort of informality versus discretion, and spectrum of informality versus criminal. So it does have to be fleshed out, but I like how other disciplines are giving us another way of looking at both legal and sort of police practices as well.
Thank you. Yasser, do you have anything to add?
I'll just say very quickly that I think what's useful about your question, Maria, is that I don't think I have a good answer to it, and that's because it's something we need to really think about, right? Yeah. I think you're absolutely right. We don't want informality to be turned into a kind of catch-all term for anything that's not formal. And there's something I think we are working through figuring out. We need to work to figure out what that means. I think that what I think you've pointed out is there a particular maybe moral or normative baggage that the word informality contains, right? That there's and are there other actions that have a different moral aspect to them or normative aspect that we don't want to loop in or lump in with the kind of some of the practices we are discussing here as well. But I also think that it also brings up the question of the politics of labeling, right? So which informal practices get deemed criminal and which don't, and why, right? That's also an important question, right? The politics of labeling things as simply informal and politics labeling things as distinctly criminal or violent, and why do we do that, right? So I think these are all questions, and I take your invitation as something that we really should be using and thinking through more rigorously in our work, and I'm hoping we do.
Yeah, absolutely, and I just want to echo what everybody else has said, particularly to the informality concern. I think we deeply share that concern, and one of the reasons why we actually got together was to actually try and think through this. Because when we're looking at things from the legal perspective, the legal informalism narrative is really built around alternative forms of legal ordering. And that to us is very constraining, because we're not just talking about lok adalats, we're not just talking about panchayats or jirgas, we're really talking about something informal, in the domain of the informal, but not necessarily in the domain of legal ordering. So that is why informality was an interesting sort of expansion of those frontiers, but completely take your point that we don't want to expand it to a level where it becomes completely undifferentiated and, as you said, a catch-all. So thank you so much for that pushback. And thank you all. Thank you to the panels, members, and all the audience, and thank you for this rich engagement.